All right, Edgar, thanks so much for taking the time to speak with us about this topic right now. Obviously, it's on a lot of people's minds. We're seeing a lot of interactions between civilians and law enforcement, in this case, immigration enforcement. And obviously, what you do is you look at these interactions and where accountability can lie and how people can maneuver around that. Universal constitutional remedies, right? This is the concept. Can you explain that to us?
So before I do that, let me just start with a little background. You'd probably be surprised to hear there's not much you can actually do if federal agents violate your rights. There is currently no viable way to sue federal officers personally for such violations. If an officer who pulled the trigger on Renee Good was a local police officer, the family could file a lawsuit, get into court, demand accountability, and eventually a jury will decide what happens. But because the officer who shot her was a federal officer, there's currently no practical legal mechanism to sue federal officers for personal liability. That's the system we have right now. You have the rights, but you have no remedy when it comes to federal officers. The good news about the Universal Constitutional Remedies Act is that where the federal law fails to protect us, state law can. It's about creating this badge neutrality. Basically, we're taking the exact same law that local officers are already held accountable for, so it's not increasing their liability, but we are applying them to federal agents through state law. And that's badge neutrality because justice should not depend on who signs the officer's paycheck. And if you don't mind, I'll talk about how that works.
Yeah.
So, the Supremacy Clause is not an absolute shield for federal officers. The clause states that federal laws are supreme only when made in pursuance of the Constitution. And the logic is this: if a federal officer acts unconstitutionally, their actions are, by definition, not in pursuance of the Constitution. Therefore, those actions are not supreme and can be subjected to state level consequences. And currently, there's a gap, right, in the legal system where citizens can sue state and local officials for damages under, USC 1983, but have no equivalent statutory right to sue federal officers for monetary damages. State law that creates a cause of action bridges that gap. This gives the individual the legal permission or the cause of action to sue federal officers in court for constitutional violations, just as they would with local and state officers. And I'll just bring up this point. This is not a radical new theory, but one rooted in history. So in a 1882 case, U.S. v. Lee, the court ruled that federal officials were not protected by the Supremacy Clause when their actions, their seizing property, were unconstitutional. Akil Amar, who's probably the country's leading constitutional law scholar, laid out this concept in a really influential 1987 paper called Of Sovereignty and Federalism, arguing that states have the power to provide remedies for federal constitutional violations. So that's the background.
Yeah, and I think you'll probably repeat yourself a couple times as I ask my follow-up questions. But so this mechanism, let's you said there is some sort of history behind this, right? It's
Right.
not a new concept. So from your understanding, what has gotten in the way of having a mechanism like this available to someone?
Well, I think states we're not thinking about this. So this is very legal. This is something that has been historically rooted. And so people have been approaching it from the federal angle. And I don't, without going into a deep legal explanation, but in a nutshell, it's because federal law lacks a cause of action. Like I said, the legal permission. And the Supreme Court has severely limited prior pathways under case law. And so that path has closed, but the state path has always been open. And this is a time where states are recognizing this and they're taking action.
You mentioned the Constitution, and if an officer is acting unconstitutionally, right? To say
That's right.
and would that be a state constitution or the U.S.
The
Constitution?
US Constitution.
So it'd be the U.S. Constitution. They'd be infringing on those rights in a state. So if I'm suing at the state level, right, that would be to the U.S. constitutional rights applying to a state court.
That's right. US
Okay.
constitutional rights always apply to state court. It applies everywhere, right? Because that is the US Constitution is supreme. So Whether you could sue in state court, you could sue in federal court, it will likely be removed to federal court. So it's still going to be going through the federal court system. But it is basically a cause of action pointing to the US Constitution, which is the supreme law of the land.
Yeah, that was my next question is would this do the all of would all of this and eventually just go to federal judges? Like
It's
this
very likely.
so
Yes.
it wouldn't just stay with is there a state judicial system equipped to do this? Are they able to? Or do you think most judges would just say this is a federal issue?
I think this is very likely to be removed to federal court. And so this will likely end up in the US Supreme Court.
So if I guess walk us through what this would entail. If I feel like my constitutional rights were infringed upon by an officer, what would I do if like in New York State say that the New York Civil Rights Act was on the books? What would be my first course of action?
So you would sue, a civil rights attorney will likely sue on your behalf. You would sue in state court. This is a standard move that, plays out in courtrooms and court proceedings. It will likely get removed to federal court, and that issue will then be litigated there. If which we do feel that this law is very sound. And so, you know, if you win, if a federal jury awards you damages, then you will be entitled to your damages.
So it would end up going to the court and the jury would have to say whether or not your rights were violated, right?
That's right.
Okay.
That's right.
So I think that concept, obviously, you look at where it could apply and you look at different instances. And I mentioned this beforehand of what the threshold could be for that. If someone we saw what happened in Minnesota, you heard some officials come out and say, these people were infringing upon law enforcement action. Can you give me like what does that mean? Is there a threshold of infringement, right? Is it standing in the way? Is it blowing a whistle? Is it physically doing something?
So I think those are two separate issues, and I'll explain.
Okay.
I was formerly an assistant public defender, so I had clients resist arrest or, infringe on officers' activity, right? Where they were, let's say they're resisting arrest, but because they were physically non-compliant. And in a hypothetical, even if that client was the wrong person, the prosecution could still technically charge them for obstructing if the elements were met. This Universal Constitutional Remedies Act deals with the back end of things, with civil rights, with civil remedies or damages, namely personal liability for officers who violate someone's constitutional rights. So right now, what some federal agents are operating with a sense of invincibility, right? Pass this law, and that changes their calculus. When personal liability is on the table, people might think twice before they violate someone else's rights.
Broader, and I know obviously in the legal world, precedent is important. I don't know if this would apply there, but we've had some other discussions about mask law, making sure that the masks aren't allowed on federal, and I think someone would say, well, how could a state that dictate what they're wearing as a federal entity? Do you see anything there? Is that a possibility? Is there a mechanism for that? Could something like this rationale apply there?
I am not really versed in the mass law, so I can't say there. But what I would say about this law is that it points to the US Constitution. It mirrors the current language of 1983. And so it's creating a state version of that and citing to the US Constitution. So I don't know enough about the facts behind the mass law to give that answer.
How broad? Because I know I asked the sponsor of this New York Civil Rights Act about the bill after the governor brought it up at the State of the State. How broad is it? She had talked about, hey, we want this to apply, beyond this to make sure this can happen in a lot of different ways. Do you know that?
Yeah, I think any clearly established constitutional rights are on the table, right? So, for example, could it potentially protect constitutional rights of universities subjected to pretextual funding cuts under a university's First Amendment rights? Could media company facing increased regulatory scrutiny due to disfavored coverage, have a First Amendment right, First Amendment claim to this? Individuals subjected to unlawful politically motivated vindictive prosecutions, First Amendment, Fifth, 14th Amendment, nonprofits subject to retaliatory, spurious tax audits, First, Fifth, 14th Amendment. So things that have already been deemed as constitutional violations come on the table.
And finally, and this is a follow-up from earlier, and I wanted to ask it in terms of the accountability right now and ramifications for unjustified use of force, constitutional rights being infringed upon. What is there right now? I mean, you mentioned that there's no mechanism for someone to go and sue. Is it just within a department, someone getting put on leave or fired, right? Is it just within their own sphere?
That's right.
Yeah.
Right now, there is no outside accountability towards federal officers, so it would be an internal sort of review process.